So this is a famous case. The Asian American band, the Slants, filed a trademark application in 2010 and abandoned it in 2011. The US Patent Trademark Office assigned it slants a meaning as a racial slur and refused it as a disparaging mark, arguing that it was derogatory towards Asians. The Slants requested reconsideration, changed attorneys, but eventually abandoned the application in November of 2011. However, they did so because they were changing tactics. Their new attorney filed a new application the same month with a different strategy. This time, the application made zero reference to any Asian connections. The US Patent and Trademark Office issued the same office action, and the band asked why the office was assigning the one definition that meant a slur versus the other three neutral definitions that they had found. The office didn't say why they assigned it that meaning, and the application itself didn't reference Asian. So basically, the examining attorney on the other side was assigning it the derogatory meaning because that was his conclusion. However, the U.S. Patent and Trademark Office doubles down and issues a final office action on the same basis, saying, no, we're referencing the original application. The band members indicate that they're going to reclaim the word on that application, and the band has Asian connections. So the band's attorney again responds with, why are you looking at the old application instead of the current application, which is the standard and what's required? And the current application references zero things about Asians. That attorney makes some excellent cheeky arguments about how many Asians the band has to have before it's considered able to make a registrable mark with the USPTO, which leads us to the conclusion that the office would allow a registration if it was the exact same application, exact same mark, but zero Asian band members. Sounds discriminatory. The Patent and Trademark Office again says, no, we're not going to register this mark, we're done. So the band decides to take it to the Supreme Court. In 2017, the United States Supreme Court decides unanimously in the favor of the band, and it's on a First Amendment free speech basis. So that allows us to use words even if the ideas behind them may be offensive to some who hear them. The U.S. Patent and Trademark Office then publishes the mark for registration. Yes, they still have to go through the USPTO process after going to court. And then they get their registration on November 14th of 2017. That's 7 years after they start this process. Wow. Moral of the story is a good attorney and good strategy can get you pretty far.